Courts Act.
My humble
So it is the district judge, the commercial division, which has been designated as the appellate forum. So the High Court does not have the jurisdiction because it arises out of a senior judge, the judge of senior division. Exactly, my lord, the same thing, my lord, had happened. My lord, if your lordship, my lord, takes up this judgment, a very recent judgment, your lordship kindly comes to paragraph 13.
Okay. Paragraph 13.
The government of Assam, by its notification dated 13th of February 2019, has designated all the courts of civil judges senior division as commercial courts. Then, my lord, your lordship kindly comes to paragraph 15. That deals with section 13(1) of the Commercial Court Act, provides that any person aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the Commercial Appellate Court. Paragraph 15, your lordship kindly sees, kindly mark that sentence, aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the Commercial Appellate Court within the period of 60 days. And then, my lord, since by the aforesaid notification dated 13th February 2019, all the district judges of the state of Assam has been designated as appellate courts at district level under Commercial Courts Act, the appeal from a commercial court, the Court of Learned Civil Judge Senior Division, exactly ours, would lie before the Court of District Judge Kamrup, as same is the Commercial Appellate Court. So the High Court does not have jurisdiction. And finally, my lord, your lordship comes to paragraph 20 and 21. Thus, it appears from the observation made by the Apex Court in paragraph 24 of the aforesaid judgment that since the Commercial Courts Act 2015 has been enacted later at a point of time than the Act of the Arbitration Act 96, it is the later Act which will prevail. Here also the same. 1999 Act is the Trademarks Act, and here, my lord, the Commercial Court Act is 2015. So the Commercial Courts Act supersedes. Then your lordship comes to paragraph 21. Accordingly, in view of the provisions contained in section 3, subsection 3 and 3A and 13(1) of the Commercial Courts Act 2015, read with section 37(1) of the Arbitration and Conciliation Act, an appeal from order granting or refusing to grant any measure under section 9 of the arbitration of a commercial court below the level of district judge, here my lord it's below, would lie under section 13(1) of the Commercial Courts Act to the Commercial Appellate Court, which is in the instant case the Court of District Judge Kamrup. So, my lord, and this appeal is accordingly dismissed for want of jurisdiction. So here, my lord, also, in view of the notification, it would lie before the District Judge Kamrup having the jurisdiction.
Lordship, from the same.
Yes.
Completed. Sir, may I?
Just one second. It's exactly what my learned friend has also been saying.
No, I am saying in a different line, Lordship. What learned senior counsel has referred, commercial courts and commercial appellate courts have been constituted under a notification of 2019. I would like to
That this notification, 13 February
Yes, Lordship.
2019.
2019 notification I have given a copy, Lordship.
Yeah.
But in the judgment of Brahmaputra distillery, I have referred this commercial appellate division's finding, Lordship, at para 15 and para 16, Lordship. I have given the copy, Brahmaputra distillery, Lordship. The Brahmaputra distillery versus associated alcohol.
Yes, yes. Yes.
Kindly refer to Lordship para 16.
Act second. Yeah.
Para 16, Lordship.
Para 16 years.
The notification number such and such dated 13 to 19 to Senior Council is referred, Lordship. Issued by Judicial Department, Government of Assam, issued under the repealed ordinance, would not have any effect whatsoever. Meaning thereby, neither the commercial court, constitution of the commercial court, neither the constitution of the commercial appellate court at the level of the district judge are in existence now, as on today. So for my personal query I have made,
Yes.
no fresh notification has been issued. Under section 3 and under section 4, government has to issue a notification in consultation with the High Court.
Yes.
In this judgment, Lordship, some suggestions have been made to the government. The last paragraphs, direction to the registry, para 24, Lordship. The registry shall send a copy of this order to the Ministry of Law and Justice, to the legal remembrancer, Commissioner and Secretary of the Government of Assam, Judicial Department to examine the order and to do the needful at earliest. As on today, neither commercial courts have been reconstituted, neither commercial appellate courts have been reconstituted. What learned judge brother has referred regarding this location on the judgment, Lordship. While passing this judgment, the earlier judgment was not considered regarding the nullity of this earlier notification itself. So I leave it this matter to Honorable Court. Here I am in the sufferance. Injunction order is against me, but as this has come to my notice, I have brought it to the notice of the court, Lordship. Whether
So which is the appropriate court now? Of appeal?
Lordship kindly comes to paragraph 17 and 19 of this judgment, which has been cited by my learned friend. Malad, the remedy is given. Malad, the remedy is given in this judgment itself. Malad, your Lordship comes to paragraph 17. Therefore, till the appropriate government takes
Paragraph what?
paragraph 17, my lord, of the judgment cited by my learned friend.
17.
Yes. Therefore, till the appropriate government takes remedial measures on the principle that a litigant cannot be left remediless, the instant appeal having been filed under the provisions of Order 42, Rule 48, Rule 1-2R.
No, 47.
47 ought to be filed before the court of the district judge Jorhat as per the mandate of section 13(1) of the Commercial Courts Act 2015. So it gives a remedy. It should not be filed here. It should not be till the government comes up with a notification, cannot be left remediless. So he can file the matter before the district court, district judge at Kamru.
with all respect.
Then, my lord, your lordship kindly comes to paragraph 19.
So now what will you?
Now, my lord, kindly comes to paragraph
No,
19
no.
once, my lord. Paragraph 19.
Paragraph 19.
It may be stated that as per notification number 56 dated 16th August 2024, issued by this court, the civil appeal valued at 20 lakh and above can be taken up by the High Court. However, none of the provisions of the Commercial Courts Act 2015 prescribes the upper pecuniary limit of the court of the district judge to take up appeals. Therefore, ouster of jurisdiction of Gauhati High Court inheres in section 13(1) of the Commercial Court Act, as this court does not have original civil jurisdiction and is not the designated appellate court for the purpose of suits and proceedings under the Commercial Courts Act 2015. 21. Therefore, in light of the discussion above, the present appeal is liable to be returned to the appellant so as to enable the appellant to present this appeal before the court of the learned district judge Jorhat. So it gives a remedy.
So there is an interregnum period.
Yes. So it gives a remedy.
Period.
Lordship, I have one just doubt in my mind, Lordship. Once in the same judgment, notification was nullified. No commercial court in existence as on
No,
today.
see, this
No
is the DD
commercial
judgment. I
appellate-
cannot interfere with
No,
the
that's
DD
why,
judgment.
Lordship. The limitation is 20 lakhs has been dealt with here.
Yes.
So my humble just opinion, Lordship. Matter may be placed before the commercial appellate division, where I would like to argue on this line.
Correct. That's what I'm saying. He can go before the commercial appellate division district court judge at Kamru.
Because
He has the right.
to my mind, like Lordship, having the jurisdiction of 20 lakhs one part, my case is of 10 crores here.
Correct.
Second part, non-existence of the commercial, non-constitution of the commercial appellate court by government of Assam. Whether a district judge can take, though the judgment has given this
Power.
remedy or power.
Correct.
Within the.
Yes, within the
Interregnum.
interregnum period.
But as per law, unless constituted by government of Assam, whether they can take.
Of course they can. By the dint of this order, they can take.
Really, Lordship, I am in doubt on that.
Because
in one
always,
hand,
my lord,
the
the
judgment
courts have
has-
intervened, saying that when any court is not there or not
I
created,
am nowhere. I have to argue my case.
it is the
For
writ
certificate
court
that
or
appeal.
whatever, it is
Whether
that
before
court
your
which can
lordship,
take.
before appellate division or before district judge. I have no objection on it.
Very well. But then this
But,
judgment follows in the interregnum
far-
period.
Doubt is concerned regarding once notification is nullified and district judge has a jurisdiction under this court up to 20 lakhs only. This case is of 10 crores. Can.
My lord, it says that the district judge does not have an upper limit. It says that in the order.
But that court is not in existence.
Of course,
that is
that's for the
dilemma here.
interregnum period, not
That is
to.
the dilemma.
So district judge is limited to 20.
Yes,
That is the
not,
dilemma.
not to render remediless,
Dis-
someone remediless.
District judge has been nominated as a commercial appellate court under a notification. And that notification is not in existence.
I think civil judge senior division is having jurisdiction above 20 lakhs.
No, they have got unlimited
Yes,
jurisdiction in Assam.
So.
Assam has unlimited. So far appeals are concerned against the orders of a civil judge, senior division. There is a limitation.
Well, if my learned friend says something different, that means it's different from the order or the directions which has been given by the Honorable Division Bench.
I will be,
Now that he cannot do.
So like the.
He has to follow
earlier
this.
case, I will send it like the earlier case you have referred to. You
Got
want
you.
to send it back.
Yes,
And
and
you have no
also
objection
this
if I
one, my
send
lord.
it back.
I'm relying on this one also.
no, that I
The
have no
judgment of my learned friend also, that gives the same
specific
remedy.
order may be made, that yes, my appeal may be returned to me
Yes.
with saving of my limitation period, Lordship. I'll go there, no problem.
My lord, in fact, my lord, there is a second issue out here. No, that he can take. It's not a problem. They have to file a section 5. My lord, the appeal that has been filed out here is without a section 5.
Hmm.
Now, this appeal was barred by limitation. The appeal is, there is a delay.
I will answer
Now,
that.
without
question,
that
Lordship.
section
When
5,
I
also,
answer that
my lord,
question.
let them go back and return and do whatever they want. They have the right to file a section 5 even after filing of an appeal. The appeal cannot, my lord, that
But as per my humble opinion, Lordship, in the earlier matter, Brahmaputra, FA was registered, matter was placed before the Honorable Commercial Appellate Division.
there was no question of limitation.
So some clarification on the earlier judgment also, Lordship.
But
In
in
one
fact,
hand,
your-
notification has been
It's
nullified.
very clear what clear.
My lord, your lordship can in
I
fact
doubt-
follow my learned friend's judgment, my lord, which he has placed. My lord, that gives the remedy.
What the judgments are clear?
No, I have no problem, Lordship. I have to argue my case.
I believe it is clear.
Yes,
No, Lordship,
it's very clear, my lord, it's very clear.
as your Lordship decide, I have just pointed out.
I cannot decide it instantly. I'll have to ponder over the matter. I'll
Lordship,
go through both the judgments you have submitted,
Lordship.
the division bench
Let your
judgment.
lordship would kindly, my lord, consider paragraph 22 while passing the other. Because that will be necessary
Paragraph 22.
of my learned friend's judgment.
Please read. Paragraph
My lord,
22.
yes. This appeal was presented before this court on 18th of November 2025. Accordingly, considering the intervening court holidays in the remaining part of this month, December 2025 and January 26, this court is inclined to provide that in the event the appeal is presented before the court of the district judge within the outer limit of 3 weeks from the date of this order, the time spent in this court from 18/11/25 till presentation of the appeal within outer limit of 3 weeks from the date of this order shall be treated as time bona fide spent before this court pursuing this appeal as per section 14 of the Limitation Act. That perhaps that liberty needs to be given to my learned friend also.
No, I am leaving it to the Honorable Court, Lordship. I want to just have my
I,
appeal heard.
I don't think you will suffer any.
No,
loss.
nothing.
I am not going to Lordship, but my simple query, once
If it is sent
notification
back
has
to the
been.
appropriate court, and then when the government has not come up with any notification with the discussion of the High Court, has not come up with any notification, then the best remedy will be to, I think so, send back.
As your lordship,
But even then, I'll ponder over the
As your
matter. Maybe I will pass an order.
as your lordship deems fit, I have no objection either way. Sending it to the commercial appellate division, sending back to the district judge, returning my petition for presenting there with a closure like in the judgment, saving of this limitation.
Yes.
I have no objection. I have no objection.
Yeah.
That will be recorded.
Grateful.
I'm a person.
No, there is one thing, that if this appeal is returned before the district judge, then the appeal has to be in the same manner as it is out here.
Same appeal will be filed there then, same
It
appeal.
cannot be filed. It is returned. Now, if it is a fresh appeal which needs to be filed, then it has to be dismissed or withdrawn, and a fresh appeal needs to be filed.
If it is returned, I can file the same memo there.
Same thing has to be filed. It cannot.
But here in this case, you have relied upon.
Yes,
It has been returned.
it has to be returned.
Yes.
If
It has
one
been
case
It
returned.
has to be returned. My
So
lord,
if you are relying
the
on this
judgment that I
case,
have relied on
it
is
has been
dismissed.
returned. Dismissed.
Yes, for want of jurisdiction.
Let me check. Oh, I thought it was
That
returned.
no case
Paragraph
filed.
22, my lord. It was dismissed.
This Brahmaputra is by you, no?
That is no. Two judgments, one given by.
My judgment, my lord, the Lokesh Anand, the last one, March 2026.
The location, let me see.
Yes,
last
paragraph 22.
With a liberty, it has been dismissed.
Correct. I am also not saying that you can have the liberty. I don't have any difficulty.
I'll
But-
pass a similar order.
No, lordship, in the Brahmaputra judgment, it has been returned,
It has been returned.
giving me time of 3 weeks to file, outer limit of 3 to resubmit it before the district court.
So what is the problem? If it is returned in
No, no, no.
similar to the earlier judgment, where is the problem?
I don't have any problem, but the same appeal has to be filed. There cannot be any change.
We will not change, lordship. We will not definitely going to change anything.
That it will be seen at the later stage.
Because this record will only have to go there if it is returned.
Same appeal memo will go there.
This record will go there.
What, 20%?
Your lordship, the judgment that my learned friend referred to, paragraph 23 also says that.
Paragraph 23.
Yes,
Returned.
23.
Returned with an outer limit of 3 weeks.
No, 23, mother. Directions to the registry. Last page. Last page, mother.
Brahmaputra.
No, yes, Brahmaputra. Last page.
Be returned.
Let this appeal, along with the certified copy of the impugned order and wakalatnama, be returned to the appellant after keeping a photocopy thereof for the record.
That is the return part.
So the same record has to go there.
No. What was this calling? Yeah.
Gratefully.
Mm.
Well, you have given any date for judgment?
If I can pass an order today, I'll pass
Very
it today.
good. I'm
Otherwise,
grateful.
I'll fix a date for order.
Grateful.
Lordship, in this case, I was supposed to file affidavit. The affidavit is running from one corner to another because the person who was supposed to sign the affidavit, Lordship, till 9th he was in Assam campaigning all across,
Mm.
and thereafter he is in West Bengal. Tomorrow evening he is completing his campaign and he is coming back.
Okay.
So Lordship may take up this matter next Wednesday.
Any objection?
No, my lord, there is a problem. On 29 is the date fixed before the learned trial court. Now, trial court is insisting that we should file the written statement. Now, this is the third or fourth time they are taking time, my lord. I think it is third time. So therefore, my lord, therefore, it is on their prayer that lordship has granted time, that should be indicated. Otherwise, in the trial.
As a last opportunity given, or
Kindly
else,
see,
if I
please,
fail,
please, kindly
if I
have
fail
the
to,
last
if I
one.
fail to file affidavit, Lordship may call for the else here for taking up the matter for hearing on Wednesday or Thursday. Let the else here be called
One
for.
for last order was passed, my lord. Kindly see paragraph number 5. Learned so and so for the respondent one submits that though the affidavit to be filed with the respondent number is ready, however, signatures thereon could not be obtained as it takes some time for filing written objection against the interlocutory application. Same prayer was made the date before that also. So, my lord, in the order, it should be clearly indicated that at the instance of the respondent, that this time is being granted.
I have no, everything we are speaking the correct position. For even for all government activities also since the model code, nothing is progressing. Here also the person is actively involved in the election process in Assam as well as in West Bengal. So whatever I am submitting, it is totally correct. I have a copy of the affidavit also, which one person is running all across the villages in West Bengal yesterday.
Learned Senior Counsel, Mr. K. Chaudhary is present for the appellant. And learned AG, Mr. D. Sukia is,
I'm as a senior counsel here, Lordship,
okay,
not as an advocate general.
yes, of course. Learned Senior Counsel, Mr. D. Sukia is present for
For the respondent number 1.
the respondent number 1. Anybody for other respondents? 2, 3, and 4?
They are pro forma respondent.
Their notice is also required to be served, Lord.
And and is submitted that the affidavit to be filed by the respondent number 1 is ready, but signatures could not be obtained as the respondent is busy and is out of station. Okay,
Busy in election, Lordship.
busy in election and is out of station. He's returned.
No, tomorrow night he is
And
returning.
he and is out of station. Full stop. On submission by the learned Senior Counsel, Mr. D. Sukia, okay? Adjournment is allowed. List this matter. When do you want?
Thursday next, Lordship.
Thursday?
Let it be 29th, my lord.
29th?
29, 2 o'clock, Lordship. Because I'll be returning from Sikkim in the first up on
No
that day.
problem.
Yes.
At 2 o'clock,
29 at 2 p.m.
Lordship. Yes.
You know, only thing Lordship will kindly make an observation that this our
That's
appeal.
why I'm
No,
referring to
no,
PM.
our prayer could not be taken up because the affidavit is not there. That has got a significance. Nothing
And
else.
what about the other respondents? Their affidavit is also required.
They are pro forma. They are pro
You
forma.
want me to pass an order to issue
No,
notice?
Lord, no, all that I'm
To other
saying is,
respondents?
all that I'm saying is, because of the predicament in the trial court, my lords, this our appeal for
Your last
stay
date is
could not be
29.
taken up because they have not filed their affidavit. That's what it should be clearly indicated in the order.
Learned Senior Counsel, Mr. K. N. Chaudhary has raised objection stating that this matter is pending for
It-
what? In the trial court?
Affidavit to be filed by defendant number, respondent number 1.
In the trial court.
Yes.
No, no.
Otherwise, trial court is insisting and why? Because every, on the 2-3 dates have gone.
Affidavit or WS?
The WS by
WS.
the other side, the petitioner here,
Or WS to be filed.
not by us.
a
No,
trial
definitely
court or,
WS by filed by the defendant.
Trial court. By on WS to be filed by a defendant in the trial court on 29/4/2026.
Highly obliged, Lordship.
No, my lord, I couldn't follow, my lord, whatever. All that I
I'll
said.
arrange it. I'll arrange
No,
it
my lord, all
according to
that,
your
no,
submission.
no. All that I was submitting.
I'll ask him to read it out.
This, my lord, our prayer could not be taken up because they could not file the affidavit. I just wanted to indicate that only. Nothing else.
As
Because they
the
have taken time on 3
objections
occasions.
As the prayer of the
Appellant
here your appellants could not be taken up
for the want of their affidavit.
for filing of, due to, for filing of their affidavit.
Yes.
বাকিখিনি কাটি দিবা।
The previous part may be deleted.
Yeah, we'll-
Lordship, regarding the lower courts matter.
Yes, it will delete it. 29 will be with me.
Highly obliged.
Develop.
It will come according to your submission.
Yes.
Lordship.
I'll tweak the order according to your
Yes.
submission.
Well, appeal admitted, my lord. Statutory appeal.
Yeah, yeah.
Yes.
Why are you agreed by the order of the?
Sir, I am
chamber?
the wife, man,
Okay.
and if the respondent is husband, man.
Hmm. You were not given any alimony? The, okay, EC, no?
Yes.
So we'll have to frame
Probably-
substantial questions
Yes.
of law. What are the substantial questions of law? Which page? Okay. One will frame. Two also will frame. Three we won't frame because evidence not required.
That's
Only substantial question of law.
1, 2, and 4.
1, 2, and 4. Learned Counsel, Mr. K.K. Bhatta is present for the, which number, item number? For the appellant, United Insurance Company Limited, full stop. The appellant is aggrieved by the judgment and order dated
Date 2026.
Oh, yes. 3/2/2026, passed by the Commissioner Employees Compensation in EC case number 218 of 2024. Awarding a compensation of rupees 2,88,632 to 88,632 without by assessing the by assessing the loss of earning capacity at the rate of 24%. All right?
Yes, yes.
Full stop. The appeal is admitted on the following substantial questions of law. A to 1 to 3 বুলি লিখি দিবা, কিন্তু 3 to নিদিবা. Page substantial question of law tag mark 1, 2 মই tick mark কৰি দিছো আৰু 4 to দিবা. 1, 2 আৰু 4 to দিবা. কিন্তু লিখোতে 1, 2, 3 বুলি লিখিবা. Issue notice to the respondents, returnable within 4 weeks. List accordingly. How many respondents? 1 or 2? 1 only, I think.
Let's say 2 respondents.
Huh?
2 respondents, let's say.
2 respondents. Okay.
Record may be called for.
Respondents, also call for the original records. Of EC case number 218 of 2024.
Item 6.
Yeah, please. Not appeal for enhancement of quantum of company award. No, the award has been passed against the owner of the vehicle.
We'll admit it.
Yes.
Heard Mr. M. Ali,
Yes, yeah, my lord. Mine
Are
is
you
not
sure?
shown in the cause list.
not soon, no?
Yes. But,
Okay.
but in the Ukalatnama, my name is.
Okay. Heard Mr. S. A. Ahmed, learned counsel for the appellant, Anwar Hussain, who is aggrieved by the judgment and order dated
Not 11/7/2024.
11/7/2024 passed by the learned member MACT Dorong Mongoldo in connection with MAC case number within bracket small I, bracket close, 54 of 2018. To stop, the appellant is aggrieved by the quantum of compensation, which is not, which is minimal, full stop. Learned counsel, Mr. R.C. Paul is present for the insurance company.
Respondent number 1.
Stroke respondent number 1. Admit this appeal, full stop. Notice has been accepted by, you have received notice?
Yes, it.
Have been accepted by the
Respondent number
respondent number 1, and thus no formal notice is required to be issued, full stop.
Not necessary. Even three.
However, issue notice to the other respondents, 2 and 3, returnable within 4 list accordingly. Call for the original records from the tribunal, okay?
Much.
Wait, Prijala, not a statutory appeal will not for arrangement of compensation.
Heard Mr. A. Lal Laner counsel for Srimati Lily Borua, comma, the appellant, stroke claimant, who is aggrieved by the judgment and order dated 15/12/2025. The appellant is aggrieved by the quantum of compensation and has thus prayed for enhancement of the quantum of compensation, full stop. Admit this appeal, issue notice to the respondents, how many?
Two responding.
Issue notice to the respondents, returnable within 4 weeks. Call for the original records from the tribunal, list accordingly.
I'm of it.
Item 9.
Connected appeal will 8 and 9 are connected will arising out of the same accident.
Okay.
It can be admitted, Lordship.
Learned counsel, Ms. R.D. Mohinder is present for the appellant, comma, New India Insurance Company Limited. Full stop. The appellant is agreed by the judgment and order dated 15/12/2025 in connection with same case, the MSC case number 900 of 2018, no?
Lordships?
900 MSC case number 900 of 2018.
Yes, 900 of 2018.
Why are you agree?
Because Lordship, it is in the same family. The claimant is the wife, the owner is the husband, the
Okay.
deceased was the son. So there is a law point involved,
Okay.
serious law point involved.
Admit
And
this.
other than that, on quantum also.
The appellant is, the appellant is also agreed by the quantum of compensation and on other, and other points and other,
Substantial point of law.
and other substantial point of law, full stop. Issue notice to the respondent, returnable within 4 weeks.
I can
Admit
hand over
this
the
appeal.
copies to Mr. La because he is appearing for 1 and 2. Already for 1.
No,
he have-
only one lot.
Admit this appeal,
One of them.
2 as well.
Oh.
Husband or
Husband opening for them too.
list accordingly,
For-
same
for-
date.
Lordship,
List
for
accordingly.
1 we have already given them.
For one we have
copy.
received, for two only they have to take this.
I thought he'll appear because he is the husband. Okay, I'll take.
There is opposite party. Opposite party.
Learned counsel, Mr. A. Lal is present for the claimant and has accepted notice and copies of the appeal.
Caveat may be discharged, Lordship. He has
Oh, you
filed a
have.
caveat.
Caveat to discharge কৰিবলৈ order এটা লিখি দিব হা, caveat এটা আছে। তাতে লিখি থৈ দিয়া caveat discharge বুলি।
And in-
Caveat is present, caveat
I
stands
could-
discharged.
I should wait it.
I say meeting.
The I is there, Lordship, one I is there.
They can file their objection in that,
No,
Lordship.
Lordship-
No, Lordship and need.
We don't need to file an objection, my lord. Let them argue.
You want to press the IA?
Lordship,
No.
it will be there, but they have to file an
I have no,
objection.
I don't have to file the
He doesn't have
objection.
any objection.
Then Lordship,
Let
then
it-
Lordship may stay the whole.
Whole amount cannot be still 50% they have to deposit, my lord.
No, Lordship.
If it's a
Deposit,
period-
in this case, Lordship, deposit will be difficult at this point of time because I said, Lordship, it is in the same family. The son died.
Then you don't press the IA, okay?
Right now, let it be in abeyance, Lordship.
There has to be an order, my lord, they are not pressing the IR. Let it be in abeyance.
Not that
And there-
pressing.
Some
I'll
order,
go here
Lordship,
for
the
that,
matter is
Lordship.
listed, lord. Some
Lordship-
order has to be there.
I'll do a hearing on that, Lordship. I'll present it
But
today.
today there has to be some order. Madam, there has to,
সেইটো লিখি দিয়া, Learned Counsel Ms. R.G. Mozumdar has submitted to take up the IA on the next date.
Yes, Lordship, highly obliged.
Lordship may kindly fix a date in that matter, my lord.
দুইটা কেস 8 and 9 ডেট এটা দি দিয়া হেৰি accordingly নালাগে ডেট এটা দি দিয়া 4 weeks or
25th of May. I am deeply obliged, my lord. Lordship, can I in the first week of June, my lord, May, Lordship, 27, I will visit Sikkim.
can be
2nd June. I am deeply obliged, my lord.
Wait, this is your Lordship. This is also a statutory appeal, Lordship. Lordship, in this case, what happened, the deceased was also driving a vehicle and the insurance company adduced evidence by the GD. And it proved that in fact, the deceased was responsible for the accident and not the vehicle which did. So, but the court has not attributed any negligence on the part of the deceased and passed the judgment. So that is.
Learned Counsel Ms. R.D. Muzumdar is present for the appellant. The appellant is aggrieved by the judgment and order dated 2/3/2024 passed by the learned member MACT number 2 Kamrup M in connection with MAC case number 71 of 2017. Which the insurance company is aggrieved by
And
the,
also quantum, Lordship.
by the quantum of the compensation, and also it is submitted
Negligence.
that the accident occurred owing to the negligence of the driver, which was not considered by the court. To stop, admit this appeal, issue notice to the respondents returnable within 4 weeks. To stop, call for the original records to the tribunal, list accordingly.
The second one is analogous of this, the next 40 is analogous of this only one, same arising out of same accident.
Okay.
Same, only
Insurance
case
company
number,
only.
case number will be, highly obliged.
Case number to more change producer.
Yes.
Order,
Case
same
number.
order.
Same order.
Same order, खाली case number to लिखिएगा MSC case number, same court ना, MSC case
Same.
number 70 of 2017.
Highly obliged.
Item 41.
My lord, in this case, on the last occasion, my lord, notice was issued and TCR was called for, my lord. So my senior friend is appearing for the respondent, but TCR is not received, my lord.
Yeah, no.
May I submit also?
Hmm.
We have filed an application. IA has been filed.
Edu video to upload your.
Title.
Yeah.
So we may be allowed to take steps upon the legal error of respondent number 9.
All right. Learned. So we'll allow them to take steps.
Yes.
Hmm. Learned. Counsel Miss
And second.
M. Sukha is present for the appellant and has submitted that. An amended cost title has been submitted. And they will take steps to issue notice to the newly implemented
Yes, Lordship.
respondents.
Respondent number 9-1,
Respondent number 9-1.
Roman 1.
Learned Counsel Mr. S.K. Goswami.
And for the respondent number 1 to 6, 1 to 6. P. Upadhyay,
Learned Counsel Mr. P. Upadhyay is present for respondent number 1 to
6.
6.
And for respondent number 11, Lordship.
And Learned Counsel Mr.
R. Sharma.
R. Sharma
Lordship.
is present on behalf of Learned Counsel Mr. R. Khatamiya.
No, S.K. Goswami.
Or Mr. S.K. Goswami representing the respondent number 11. When do you want?
After 3 weeks,
This matter after 3 weeks?
late, Lordship.
I see. I'll come back after 5 minutes.
Yeah, please, Your Lordship.
Here I am appear for respondent number 1 to 4, your lordship.
1 to 4.
Yes, lordship.
As per my colleague's information, Your Lordship, counsel for the insurance company, A. Dotto and Ahmed, both are expired, Your Lordship.
Oh, really?
Lordship. Lordship may issue notice to the insurance company, Your Lordship, will be better.
I think the insurance company has to be informed.
Yes, Lordship.
A doctor and A Ahmed.
Yes.
What about Mrs. PM doctor?
PM Dotto she's not practicing here, Your Lordship. As per my information, Your Lordship.
Oh. Any advocate for United India Insurance Company?
Senior colleague.
They passed away, no?
Yes.
Okay. So which will be the best office to inform?
Regional office, Lordship.
Huh?
Yeah,
Regional office, Gauhati.
Yes.
He will be the branch manager,
No, regional manager.
regional manager. The appellant is not represented today. The learned counsel, Mr. T. Gogoi, no?
Yes, Lordship.
Is present for which respondent?
1 to 4, Your Lordship.
Respondent number 1 to 4. Your name is also not in the first list.
Lordship, I'm on behalf of Your Lordship.
Learned counsel, Mr. T. Gogoi, on behalf of learned counsel, Miss P. Bhattacharya,
Yes.
no? Is present on behalf of respondent number 1 to 4.
For Your Lordship.
I'm
appearing for lesson number 5.
learned counsel, Miss
J Ghosh on behalf of SC Bishwa.
J. Ghosh, on behalf of learned counsel, Mr. S. C. Biswas, is present for respondent number 5. Full stop. It is submitted by the learned counsel, Mr. T. Gogoi,
Lordship.
that the
Conducting counsel.
conducting counsel, Mr. A. Doctor and Mr. A. Ahmed, for the appellant have passed away. Full stop. Registry to issue notice to the, we'll ask the office to take steps.
Lordship.
Office, office to take steps to issue notice to the regional manager.
Yes.
Regional manager of United
India
India Insurance Company Limited of Guwahati Regional Office.
Yes, Lordship.
This will suffice, no?
Lordship.
And inform and issue notice.
That-
No, that will be enough, no?
That will
Issue
be.
notice. Oh, issue notice. will be enough. List this matter after 4 weeks.
Lordship.
4 weeks.
Habla, Your Lordship.
To inform that the appellant, Nala inform Nala.
My lord,
Yes.
the address of the respondent could not be ascertained, so
Hmm.
we will take step after ascertaining the address of the respondent.
Okay. Learned counsel, Miss S.
A. Roy, on behalf
A.
of.
Roy is present on behalf of Mr. S. Sahu, learned counsel representing the appellant, and has submitted that the address of respondent number 2 would not be ascertained, and they will be allowed to take steps to issue notice to the respondent number 2 after ascertaining the address. Full stop. Steps can be taken to issue notice to respondent number 2, returnable within 4 weeks. Learned
I'm
counsel,
referring for respondent number 3, lordship.
Miss M. Sukia is present for respondent number 3. What about 1?
Respondent number 1, I think, was completed.
We have 4 also, no?
4, but the 4 is a driver, and the legal heir of the driver is also could not be traced out.
Okay. Driver has passed away.
Yes, of course.
Office note dated 3/4/2025 indicates that notice was served by the process server to the sister of was received by the sister respondent number 1, served her received and the notice could not be issued to respondent number 4 as the notice, notice could not be served on respondent number 4 and notice of respondent number 4 was received by his son, who informed that the respondent number 4 has passed away about 8 years ago. Had passed away about passed away about 8 years ago. Is this matter after 4 weeks?
4 weeks.
I have declared 4 weeks, Negi. Okay, 4 weeks.
Applies budget.
Finding item 41, along with production list, item number 1. Production list. Learned Counsel Mr. A.K. Gupta is present for the appellant. And Learned Counsel Mr. S.K. Goswami is present for the respondent. Full
Wife.
stop.
Respondent wife.
Respondent
respect.
wife, full stop. The video conferencing too.
As per office note dated 16/9/23, respondent number 4 is expired and respondent number 5 is served. LCR is also received. So without respondent number 4, that matter may be hard. It is on quantum.
Only on quantum. Who is respondent number 4?
It's owner,
Owner.
but there is no policy defense is not there.
Okay.
I am for the respondent number 1 to 3, Lordship.
Only on quantum you are agreed. I can fix it for hearing. You want me to struck up the name or we'll fix it for hearing?
Okay.
Learned Counsel Mr. A.J. Sokia is present for the appellant and Learned Counsel Miss
B.S. Ojha, appearing on behalf of A.K. Gupta.
B.S. Ojha, on behalf of Learned Counsel Mr. A.K. Gupta is present for the respondent number 1 and
1 to 3.
1, 2, and 3. Office note dated. When was the last office note?
16/9/23.
Oh, long time back.
Long.
69/2023 reveals that service report on respondent number 4 has been received back with process server's remark that addressee expired. Whereas service report on respondent number 5 has been received back with process server's remark that notice was received by the respondent number by the respondent's wife, full stop. It is submitted by the Learned Counsel for the appellant that the appellant is aggrieved by the quantum of compensation and this case may proceed without the appearance of respondent number 5.
4.
Respondent number 4.
4 expired.
And about 5?
I have my wife.
Received. List this matter for hearing. On, you want a date? 2nd June. Item 14.
Please, Lordship. Lordship, as per office note dated 21/4/26, respondent number 4 is duly served. Respondent number 5 may be struck off, Lordship. LCR has been received.
Who is respondent number 5?
5 is a driver of the vehicle, Lordship.
Learned Counsel Ms. M. Sokia is present for the appellant and has submitted that the office note dated 21/4/2026 indicates that service report on respondent number 5 has not been received back, full stop. As the respondent number 5 is a driver, his name may be struck off as he is not an important party to this proceeding, full stop. The name of respondent number 5 is struck off at the appellant's risk. Learned Counsel Miss
B.S. Ojha,
B.S. Oza is present on behalf of learned counsel,
A.K.
Mr.
Gupta,
A.K. Gupta, comma, representing respondent number
1, 2, 3, Lordship.
1, 2, and 3, full stop. Notice has been duly served on respondent number 4 as per office note dated 21/4/2026. Full stop. As the records, original records are before us, list this matter for hearing. You want a date
Yes, Lordship.
on?
Authorized, Lordship.
Item 16.
Okay, matter has been referred for mediation. There is no sense of settlement in mediation. So, Lordship, respondent number 2 and 3, I am for the claimant. And I am not receiving any amount because of the government notification. They have obtained a stay order. And they have to directed to deposit 25% of the amount. That also deposited. And Lordship may strike off respondent number 2 and 3 because they are not necessary party because the award has been settled on quantum. Basically, on the notification issued by the government of Assam, that full salary will be received till date of return. Listen.
Lordship, we have deposited the stay amount yesterday.
So that is deposited, it may be released into the claimant also. Assent.
Where I'll pass the order, in the appeal or in the IA?
In the appeal. I disposed of it.
I respect for any. Oh, dispose for main case of dividend.
Respondent number 2 and 3 can be struck off, Lordship.
Okay.
Not necessary because only quantum.
Learned counsel Ms. M.C.K. is present for the appellant. And learned counsel Mr. S.K. Goswami is present for the respondent number 1 and 1, respondent
One.
number 1, full stop. It is submitted at the bar that the respondent number 2 and 3 are the driver and the
Owner.
owner respectively, and their names may be struck off as they are not necessary parties, as the appeal relates only
On quantum.
as this appeal narrows down only to the quantum of compensation, full stop. Thereby, the names of the respondent number 2 and 3 are struck off from the array of parties, full stop. It is also submitted by learned counsel Ms. M. Suikia that 50%,
25%.
25% of the compensation amount has been deposited before the registry of this court. Full stop. The learned counsel Mr. S.K. Goswami, representing the respondent number 1, has prayed to withdraw the deposited amount. Full stop. The claimant stroke respondent number may withdraw the amount after verification of the claimant by the registry.
This will be listed for hearing. LCR has received.
As the LCR is before us, list this matter for hearing. You want a date
Any date also.
on?
Obliged.
Item 16.
Lordship, as per office note dated 2/4/2026,
Hmm.
no face steps is taken on respondent number 2 and 3. Respondent number 3 ID card received, Lordship. With signature with Golak Ray.
So we can deem to be served. Not deemed to be, it has been served. Respondent number 3, on respondent number 3, you offer?
Respondent number 1, Lordship.
1. What about respondent number 2? You'll take steps?
Yes, Lordship.
Okay. Learned counsel Miss
B.S. Ojha.
B.S. Oja is present on behalf of learned counsel Mr. A.K.
A.K.
Gupta,
Gupta, yes.
comma, representing the appellant. Full stop. Learned counsel Miss M. Suikia is present for respondent number 1. Full stop. The learned counsel for the appellant has drawn the attention of this court to the office note dated 2004/2026 that the earlier an office note was put up on 27/6/2024 that the AD card of respondent number 3 bears the signature of respondent number 3, Sri Gulukre. Gulukre is respondent number 3. Full stop. Thus the learned counsel for the appellant has prayed to take fresh steps only to respondent number 2.
2 and 3, Lordship.
You want to take fresh steps? 3?
No, Lordship, only respondent number 2.
Respondent number 2. Full stop. Steps may be taken to issue notice to respondent number 2, returnable within 4 weeks. Meanwhile, we have the LCR with us? No. Meanwhile, call for this appeal was admitted earlier. So, it I have limitation of it. Okay, all right. So LCR nalai. Call for
Appellate,
action.
Lordship.
I can 17.
Lordship, as per office note dated 24/2026, respondent number 4 has entered appearance. And in regards to respondent number 5 is concerned, there is a postal remark saying insufficient address. So we may be allowed to take steps upon respondent number 5 by way of custody.
Learned counsel, Mr.
As shown, appearing on behalf of.
Som is present on behalf of learned counsel, Mr. S. Doctor. Post of learned counsel, Miss S. Ujhana.
B.S. Oja.
B.S. Oja is present on behalf of learned counsel, Mr. A.K. Gupta, representing the respondent.
1 respondent.
Number 1, post stop. Office note dated 20/04/2026 indicates that notice could not be served on respondent number 5 as the address is insufficient. Full stop. Fresh steps may be taken to issue notice to respondent number 5 after ascertaining the address of respondent number 5. Full stop. Learned counsel for respondent number 4 has filed wakalatnama. Respondent number 2 and 3 are not represented today. Is this matter after 4 weeks? Item 18. Item number 18. Parties are not represented today. On an earlier date, the parties were not present. Full stop. List this matter after 2 weeks. Full stop. On failure of appearance of any of the parties, necessary orders may be passed. Item 19.
Lordship, here there is a delay of 34 days. Respondent number 1, 2, 3 has entered appearance and 4 and 5 have duly served, Lordship.
No objection.
Third learned counsel, Miss M. Soikia for the applicant, the General Insurance Company Limited, pray for continuation of delay of 34 days in filing this connected appeal against the what kind of judgment? EC's judgment?
Yes, Lordship.
Which one? Oh, against the judgment dated 24/3/2025 passed by the Commissioner of Employees Compensation, Golaghat, in GC case number 5 of 2024. Full stop. Learned counsel, Mr.
D Secretary.
D.
D Secretary.
Lordship may pass a direction to reflect.
Oh, D.
oh,
Kher
Calcutta.
Kotari. Hmm?
Lordship may pass a direction to reflect our name in the post list.
It's reflected. Learned Counsel Mr. D. Kher Kotari is present for respondent number 1 to 2.
No, in MFA 84232 of 2025.
Yes,
Our name is
in
reflected.
the main case.
Main case.
Okay. D. No, order D. D. Kher Kotari for appearing for respondent number 1, 2, and 3.
Three.
Are there other respondents?
Yes, service is complete.
And has submitted that they have no objection if delay is condoned. Office note dated who are they? 4 and 5.
4 is the owner and 5 is the pro forma respondent, Lordship.
Okay. Owner of any industry or vehicle?
Owner of the vehicle, Lordship.
Service office note dated 21/4/2026 indicates that the respondents number 1 and 3 have not filed written objection.
Respondent number 3 is a minor.
Malaya have not filed written Malaya. Respondent 1 and 3 have not filed. Where is the note on completion of service? Receipt লাগিব নেকি?
18/11/25.
Okay. The Lavima court order dated 18/11/2025 indicates that the postal tracking report reveals that notice has been served to respondent number. Notice has been delivered to respondent number 1 and 5 on 23/8/2025 and notice has been delivered to respondent number 4 on 25/8/2025. Whose service is thereby served on respondent number 4 and 5. Full stop. It is submitted by the learned counsel for the applicants that there was a delay in 34 days in filing the appeal as
State coercion. Report state coercion.
where is your
Para 2.
para 2? The judgment and order dated 24/3/2020 was received by the Gauhati office of the appellant on 20/05/2025, which was forwarded by the dealing advocate at Golaghat by his letter dated 9/5/2025. Full stop. After obtaining certain clarifications from the advocate by the Gauhati office, the panel of advocate asks for certified copies of the judgment as well as other documents from the appellant while mail dated 16/6/2025. Full stop. After receipt of the said documents that is filed on 27/6/25, resulting in a delay of 34 days. Full stop. I have considered the submissions of the bar litigant, full stop litigant. The delay has been reasonably explained. Full stop. No malabhai is discernible. No, is discernible, could be deciphered, full stop. Appeal is, petition delay is hereby condoned, full stop, registry to register the connected appeal. Terms of the above observation, this petition is stand, full stop.
My lord, at the time of listing of that, my lord, the main appeal, my lord, our name may be.
Oh, yes. The registry to reflect the name of Mr. M. Doctor
Yes, ma'am.
and Mr. D. Secretary as in the cause list after registering the appeal. Connected appeal.
Obliged.
Right, please, Your Lordship. This matter is similar to the one your lordship dealt with yesterday, my lord. This judgment which is impugned is passed by single bench, single member, my lord. This one also has to go. Although they file an application for early hearing, my lord, unnecessarily it would be kept pending.
It is filed by earlier for early hearing, but now the order is passed.
So what-
Single bench.
Yeah. So shall I send it back to be decided by the appropriate bench?
Okay.
And I've got hold of the judgments. I've asked my colleague to get it photocopied, my lord. I'll hand it over to the master.
কালি এটা তোমাক দিছিল নেকি অৰ্ডাৰটো?
No, someone.
মিনুক দিছিল ন? Okay. So we'll dispose of this petition? The applicant.
Only difference is, my lord, in here, the single member is the judicial member. Other one, it was a technical member. But anyway, my lord, the quorum has to be 2 judges.
MFA to লিখা. Hard miss your name?
N. Ahmed.
N. Ahmed, learned counsel for the applicant. Appellant, learned counsel for the appellant. Appellants. Who have preferred the appellants Onima Bhumik, Aparajita Bhumik, Suparna Bhumik, Onindita Bhumik, and Onamika Bhumik, who have preferred this appeal against the judgment and or judgment dated 26/8/2019 passed by the member
Judicial.
Okay, member judicial of the Railway Claims Tribunal Gauhati bench dismissing. Yes. Dismissing the
Original application.
application filed by the applicants. Post of third Mr.
B. Sharma.
D.
B for
B.
Bangalore.
Sharma, learned standing counsel. Learned
Railway Council.
Learned Railway Council. Full stop. I have considered the submissions at the bar with circumspection. It is submitted by the learned council, learned Railway Council, that the impugned judgment and order has been disposed of by a single bench, contrary to the which is contrary to the provisions, or which is contrary to the judgment and order passed by this court in
MFA number 90 of 2013 and 116 of 2016.
and party's name.
I don't, one was Bajaj Steel, the other one I don't remember, my lord. I've given the copy yesterday, my lord. Copies.
Minu.
I remember the numbers, my lord. 90.
Party's name will লিখি যাবেন, party's name. তাৰপিছত order dated in MFA number 90.
90 of 2013. The other one is 116 of 2016.
Party's name, order dated 116 of two. এইটো এনে blank লিখি থৈ দিবা, party's name তাৰ পৰা লৈ লোৱা মেনু পৰা.
I can give.
Which is the other?
Other one is 113 of 2016. Party's name is, my lord, Union of India versus Bajaj Steel. The judgment is dated 18/11/2025. This is the second judgment. MFA number 113 of 2016. The party's name, the Union of India versus Bajaj Steel. Judgment is dated 18/11/2025. And the other one is, my lord, MFA number 90 of 2013. But I don't remember the judgment date. Judgment date I remember, my lord, 2/9/2006. Oh, I don't remember the judgment. Its number I remember, my lord, 90 of 2013. I will give it to the court master.
It has been held in MFA number 90 of
2013.
The party's name Supra likhi diba, ha? Party's name Supra, that side about me. It has been held in Bajaj Bajaj Steel, Supra.
Both the cases.
The learned counsel for the appellant has also no objection if the matter is remanded back to the tribunal to be tried afresh by
A bench constituting a judicial member as well as a
by a
technical
bench
member.
constituting a judicial member
As
as
well
well
as
as by
technical member.
as well as a technical member.
They cannot sit singly, my lord.
I have considered without getting into the merits of this case and relying on the decision of the Honorable Supreme Court in Ananda Kolita.
Amulya Kolita, that was followed by Gujarat High Court in some Sharma's case, my lord.
Okay, in Amulya Kolita, amuk minu rusot pai deba. This case is therefore remanded back to the tribunal, Gauhati bench, to be tried by two members constituting a bench, including judicial member and technical member. The original record from the tribunal is also returned back. In terms of the above observation, this appeal stands disposed of. Okay.
If I may just clarify, my lord, Amulya Kolita's judgment was passed by the Honorable Supreme Court. It was a matter pertaining to the Administrative Tribunals Act 1985. That judgment was followed by the Gujarat High Court. Following that, the Gujarat High Court held that the Railway Claims Tribunal cannot sit singly. Following that, our High Court has passed these two judgments, and there are other judgments also.
I'll include it. I'll include it.
I can be disposed.
As the in terms of the observation in MFA 265 of 2019, this IA stands disposed of. I do 10 calculate. Thanks. Minute pa alag le le ba.
22. There is a delay of 25 days in preferring this appeal also.
Do you have any objection?
I have no
But
objection.
appeared.
Yes.
Learned counsel Mr. PJ Burma
Yes, Lord.
is present for the applicant, who preferring this praying for condonation of delay of 25 days under Section 5 of the Limitation Act 1963, while preferring the appeal, full stop. This appeal is preferred against the judgment and order dated, judgment and award dated 9/7/2025, passed by the member MSCT Gopra in MSC case number 317 of 2022, awarding the sum of rupees 11,40,361 along with interest of 7%. Full stop. Where are the grounds?
Yes, it's been explained in from para 2 to 5, Lord.
It is submitted by the applicant stroke appellant that after receipt of certified copy of the judgment, the dealing advocate sought for a legal opinion from a senior panel of advocate and received the opinion on 20/08/2025. Full stop. The company then had to communicate with the main office
Yes.
for approval. Full stop. After the formalities. And
Lordship,
after
then
obtaining a legal opinion.
it came to the head
In
office.
the month of September 2025, we, the appeal was filed, resulting in a delay of
25 days, Lordship.
25 days. Learned Counsel Mr. M. Talukdar
Lordship,
is present for the
person
claimant.
number 1, claimant.
Claimant, respondent number 1, and has raised no objection to stop.
I am for respondent 2 and 3.
And Learned Counsel Mr.
H.A. Ahmed.
H.A. Ahmed is present for respondent number 2 and 3. Full stop. No objection has been raised. Full stop. I have considered the submissions at the bar. Full stop. Sufficient grounds have been shown. Full stop. No malafide is discernible. Full stop. Thereby, delay of 25 days is condoned, and registry is directed to register the connected appeal. In terms of the above observation, this application stands.
Lordship, while listing the appeal,
Our
one
number-
I'm reflecting that was list.
Full stop. The names of Mr. M. Talukdar and H.A. Ahmed to be reflected while registering the appeal. Reflected in the cause list while registering the appeal.
Lordship.
Obliged, Lordship. Copy of the appeal may be.
Lordship, I'll provide today.
Okay, copy to be furnished to the respondents.
Lordship.
Copy of appeal to be furnished to the respondents.
Lordship, my is order dated 33/26, Your Lordship.
And I beg apology for one point that it was asked that both the parties be appeared. My person was very much ready to come, but suddenly he felt, started vomiting and lose motion, but he could not come. He informed me over phone.
Lordship,
That is lower court submission.
What? This is the fact.
And lose motion.
Yeah, but
Very common
it
submission.
is fact, my lord. That's what to do, my lord.
Huh?
What to that?
May I please, Lordship?
Hmm.
So kindly perish order at 6/3/2026, Lordship. I have been directed to take steps upon remaining respondents, that is Lordship respondent 1 and 4, Lordship.
Yes.
Accordingly, I have taken steps, Lordship. Proceed post. By today, Lordship.
Respond number,
1 and 4, Lordship.
you have taken steps.
Yes, today, Lordship.
Today?
Yes, sir.
All right, we'll have to wait. Learned Counsel Mr.
M. Boru, Lordship.
Embro is present for the appellant. Appeal, no? This is an appeal.
Appeal, Lordship.
For the appellant and submitted that they have taken steps today to issue notice to respondent number.
Lordship, I have taken steps upon respondent 1 and 4.
1 and 4. To stop. Learned Counsel Miss.
U South, U South.
U South is present for respondent number.
Respondent number, all of them. Respondent number,
But not 1 and 4, no?
not one.
1 and 6, you have taken steps.
1 and 4, Lordship.
1 and 4. For respondent number 2, 3.
Lordship, 2 has expired, Lordship.
2 has expired, Lordship. 3, 4,
3, 4,
and 6.
and 6.
6.
5.
5, I don't know.
Let me check. I'll just check the name. 5 is Dunali Devi, daughter of Toleko Dev Sharma. No.
No.
Then what about 5? Do we have any order on 5? Respondent number 5?
Respondent 1 and 1 to 5 are family members, Your Honor.
Okay, no, notice has been served. Notice has been served. List this matter after 4 weeks.
Lordship, respondent to expired without
Expired.
issueless, Lordship. As per information, he was unmarried, Lordship. His name may be struck off from the court, Lordship.
Actually, ma'am, senior, actually, ma'am, this matter,
By a senior.
yes.
Okay, next week
Time.
then you submit next week, her senior will be there to be struck off. No complications, it will be struck off.
Lordship, interim order may be extended, Lordship.
Interim order shall remain in force till the next date of listing.
Item 25.
Obliged.
Contempt case, my lord, that neither AB nor unserved notice
Return my lord, waiting for service my lord.
Okay. Service report on one single respondent.
Single respondent.
Service, learned counsel, Mr. C. Goswami
Yes, madam.
is present for the petitioner. Full stop. Service report on respondent is awaited. List this matter after 2 weeks.
2 weeks.
May it please your lordship, as per office note dated 21/4/26, AD card as well as service report, respondent number 1 to respondent number 4 are awaiting. LCR is also awaiting.
Okay. Learned counsel, Miss
And Chaudhary.
M. Sodri is present on behalf of learned counsel, Miss. Okay, your name is here, no?
Yes, lordship.
No. 26, no. Is present on behalf of whom?
M. Ahmed.
Learned counsel, Mr. M. Ahmed. Full stop. Service report on respondents are awaited. List this matter after 4 weeks.
May I please, Lord? In this first appeal, my lord, we have filed an application, my lord, for injunction, my lord. IA 444, my lord.
Injunction?
Lordship.
What kind of injunction?
Injunction, my lord, to the aspect that the disputed property is a fishery, my lord. The respondent is an NGO. They owned a fishery and it was leased to the petitioner. From about 10 years, my lord, we are enjoying the fishery, my lord, on lease basis. And last lease was expired, my lord, on 28th of February 2024. Thereafter, lease agreement was not extended. Although, my lord, according to us, we have paid, my lord, for extension of lease amount, it was not executed. So we filed a suit for specific performance. And we also filed an IA, my lord. And in the said petition, my lord, injunction order was passed in favor of the petitioner. So they were pausing the fishery, they are cultivating fish, my lord. And in 2015, my lord, 15/12/2025, injunction petition has been dismissed, rejected, my lord. And on the basis of this rejection, my lord, we are not in position to cultivate the fish or, my lord, removing the fish. So we filed this petition. And in the meantime, after rejection of our petition, the opposite party, my lord, they tried to, my lord, fishing from the fishery. So we filed this petition. And it is admitted by the opposite party, my lord, that after the rejection of the order, the fishing activities have been done by them. In some part, they have admitted, my lord. So, my lord, admittedly, my lord, after injunction, my lord, it was passed on 3/12/2024. Case 10, my lord. Case 10 of the IA, my lord. This is the injunction order. 3/12/2024. And it was vacated, my lord, on 15/12/2025. So in between, my lord, we are in possession and it is a fishery, my lord. We are fishermen, we cultivated fish. Even our petition is rejected, my lord, we may be allowed to remove the fish. This is our case.
My lord.
And
First of all-
regarding main suit, that is pending before the trial court.
And
Even they, my lord,
you have
possession,
come in appeal against the
rejection order.
rejection order.
So even if, my lord, my learned opposite party, my lord, took possession of the fishery, admittedly, my lord, fish, my lord, does not belong to them. Fish we have cultivated, they have admitted. During pendency of the suit, we have cultivated fish. Even rejection, my lord, we are entitled our fish, my lord.
Yes.
My lord. Admittedly, the lease agreement expired on 28/12/2024. Thereafter, there is no renewal, though no extension. My brother, although has stated that he has instruction from his client that they have paid further amount for further period, but there is nothing on record to prove that they have paid any amount towards that. Moreover, the entire lease amount against the lease which expired on 28/12/2024, that also has not been paid. And to that, we have already filed our affidavit in opposition, stating that 1 lakh is still payable by them against the lease which has already expired. And further, thereafter, there is no extension, there is no renewal. They have not produced any document with this application to prove that there is any renewal or there is any payment by them. Let them first say that when they can make any payment to me. They want to cash the fees even after expiring the lease period, even without making any payment to us. On December 24 itself, the lease expired. They have not paid 1 lakh rupees of the earlier lease. Now they want that they should continue the lease. And the order of the landed trial court rejected is very much clear, my lord. Kindly see that order itself.
Page 13.
I am reading that order, my lord. Page number 13 of the appeal. I.
Page number 13 of the appeal or?
I. I am reading, my lord, that order. The petitioner OP is represented. The date is fixed today for passing of order on the petition filed by the petitioner under Order 39 Rule 1 and 2. Read with Section 151 CPC, praying for grant of temporary injunction against OP. I have already heard the learned counsel for the petition OP, including the title suit and the document filed therein. The learned counsel for the petition has submitted that the petition have a prima facie case as they have entered into an agreement with OP for possession of the suit land for fees cultivation and agricultural use. The learned counsel said that the OP in violation of the agreement so entered into between the parties and the OP has tried to dispose the petition from the suit land. The learned counsel has submitted that it is a fit case for grant of temporary injunction and the prayer for grant of temporary injunction should be allowed. The learned counsel for the OP has on the contrary submitted that the petitioners do not have a prima facie case as the contract between the parties has already run its course and the term of the contract lapsed on 28/2/24. And since then, the position of the petition is illegal and hence the petition seeking termination should be rejected. On consideration of the pleadings and argument advanced by the learned counsel for both parties, it is seen that the petitioners and OP have entered into 3 agreements for occupation of the suit premises by the petitioner for fees cultivation and agriculture use. And the last of the agreement was entered into between the parties on number 1 and the OP on 13/6/23, which was valid till 28/2/24. The petitioner has claimed that there was an oral agreement between the parties for extension of the term of the agreement and that the petitioner have spent considerable amount of money thereof and temporary injunction ought to be granted. My lord, although the Honorable Court has they had stated that there was an oral agreement and they have spent considerable amount of money. No proof of spending any money is provided by them either in the trial court or before along with this memo of appeal or before this IA. Learned counsel for the OP has denied the claims of the petitioner regarding entering the oral agreement between the parties. The terms of the agreement dated 13/6/23 clearly shows that the agreement lapsed on 28/2/24. Although the petitioner has claimed that there was an oral agreement between the petitioners and the OP, and he had spent a considerable amount of money and also paid an extra money to the OP, there is no document proof to support their claims of payment of money to the OP for extension of the agreement dated 13/6/23. Once the agreement had lapsed on 28/2/24 and it was not extended by the agreement of both parties, the same ceases to have any effect and the possession after cessation of the terms of contract cannot be said to be a legal one. The petition in such a situation cannot be said to have a prima facie case in their favor. The counsel for the petition has submitted that the balance of convenience lies in favor of the grant of temporary injunction, which has been refuted by the learned counsel for the OP. The petitioners are admittedly in possession of the suit land which is owned by the OP. The term of contract ended on 28/2/24 and hence grant of temporary injunction likely to cause more inconvenience to the OP who has been deprived of the possession and enjoyment of the suit land. The petitioner claim for the country possession of the suit land stands on a weak footing as is apparent from the pleadings and without devolving deep into the merits of the case. In such a scenario, the balance of convenience cannot be said to be lie in favor of the grant of temporary injunction. The counsel for the petitioners has submitted that the petitioner has suffered irreparable losses and injuries in case the injunction is not granted. The learned counsel for the OP has similarly submitted that the OP shall suffer loss and injuries in case temporary injunction is granted. On considering the submission made by the learned counsel for both the parties, this court leans towards the arguments.
Just a moment. See, we'll hear the appeal. We'll not dispose of the IA because I'll dismiss the IA. I'll dismiss the IA.
One more thing, my lord, I want to say. The appeal is not supported by any certificate.
We'll call for the LCR meanwhile,
Lost.
or we'll call for the scanned copies of the records.
Lost.
Appeal against order, we'll call for the scanned copies of the records, not the LCR.
Okay.
Okay?
Lost.
this IA has no merits.
But
No, no. And if I dispose of this IA, it will be like disposing of the appeal altogether.
so I may be
It will be kept along
lost,
with it.
lost.
In case if you want to press, if the
Got-
appeal takes
I-
time, then you can mention and bring this on orders. Learned Counsel, Mr. R. Lino
Lost.
is present for the applicant. Applicant and appellant, and learned counsel, Mr.
H.L. Moria.
H.L. Moria is present for the respondent. Call for the scan copies of these of the trial court records. On receipt of scan copies of the trial court records, this matter may be listed for admission. Okay?
Lost.
Or
You lost me.
last sentence.
You lost me fixed a date, madam, in between.
List this matter on.
My lord, let the first documents come from the trial court, scan copy.
Come, scan
In
copies
between,
of
it will come, scan.
come. It will take only 2 days.
Got
Second June,
In the month of May, madam,
May DD.
because my lord, fishing season will be
Yes.
start.
Fishing season, summer,
आगे बोल रहा है डिस्कस नहीं करेगा
summer, I think
Fishery, my lord. This
fishing
is
season, huh?
a.
They have
Not open.
Fishery does not belong to them. He says does not
Yeah,
belong to them.
they are NCO, my lord.
They have not even met the payment of the earlier rent.
Already not allowed. Yes.
Yeah.
Oh, here you go. Anybody wants to
It's different.
ask for a date, very short submission, any short
May.
submission? Ask for a date or.
Item number 30,
Ah.
the service is complete, my lord, matter may be fixed for a hearing, my lord.
Okay, sound 30, item number 30. Somebody else.
I have not been informed, my lord.
At 2 p.m.
My lord,
We'll
my
take it up at 2
My
p.m.
lord.
Yes.
Lordship, item number 28, Lordship.
Yes.
Service for the respondent number 1 and 2 is awaited, Lordship. There is a
Learned
clear
Counsel,
petition.
Mr. A. Kakoti
A.
is
Kakoti,
present for the appellant. Course of service for respondent number
1 and 2, Lordship, are
one is
awaited.
awaited. Is this matter after 2 weeks? It's awaited only, yes, yes.
And Lordship,
Mr.
item number
Bhatto?
35, 37 and 38, notice to be issued, listed for the first time.
35,
35, 37, 38.
for what?
Uh,
You'll have to issue notice.
Yes, sir, there was delay in filing the appeal,
Okay,
notice to
okay.
be issued, Lordship.
35, 37, 38, বেলেগ বেলেগকে লিখিবা, একেলগে নিলিখিবা। এতিয়া উইথত আছে। উইথ কে আছে? হা? আচ্ছা, separate matter. 35, 37 বেলেগ বেলেগকে লিখিবা। Learned Counsel, Mr. K. Bhatto is present. I কিতাত লিখিবা। K. Bhatto is present for the applicant. Notice to be issued to the respondent, returnable within 4 weeks. Okay?
Step by usual procedure.
Steps by usual process. List the matter after 4 weeks. 35, 37, 38.
May it please your lordship, item number 29, we may allowed to take fresh steps by ascertaining the correct
Learned
practice.
Counsel, Miss
Disha Goswami on behalf of R. Goswami.
Disha.
Yes.
D. Goswami is present on behalf of Learned Counsel, Mr. R. Goswami, and has submitted to and has prayed to take fresh steps to issue notice to
Respondents.
respondents. Steps may be taken. Fresh steps may be taken to issue notice to respondents, returnable within 4 weeks. List accordingly.
And item number 31, kindly it may be passed over for timing.
Yeah, sure. It's pass over for the timing.
Okay. Oblige my lord. After 4 weeks,
Upon SPA number 2 and 3.
Okay. Appellant is not represented today. Whether any steps have been taken?
And
Last was 12 to 26, no?
Lordship.
Hmm.
And
25th
TCR
of-
reminder was also sent, but I'm not quite sure if it has arrived.
LCR is present. LCR has arrived. The record from the trial court, that is the court of the MA, has been called for by speed post. It may be mentioned here that, oh, no, nothing. LCR has called for is not received, nor any steps. Okay, step, no any steps, no. Some office note dated 1/2/2026. Nalage, ito nalage. Nalage ito. Service nalage, ito nalage. Learned Counsel, Mr. R.P. Sharma.
SP Sharma.
SP Sharma is present for the insurance company. List this matter after 3 weeks.
Your lordship, service may be awaited because we have taken steps on the 24, 26.
Okay, service report on how, which respondent? All
Respondent number 1 to 4.
Respondent number 1 to 4 is awaited. Learned Counsel, Ms. Agota Likidia, Learned Counsel, Mr. SP Sharma is present for the appeal. Tabisha Likidva, service report on list this matter after 2 weeks. All right. Item number 45, 46, 47, and 48.
May I please, your lordship?
Yes, yes.
Lordship, in this case, the claimants have filed 3 make appeals for enhancement of compensation, and insurance company has filed 2 make appeals. And in item number 47, as per the office note, the notice has been served to the opposite number 2 in the given address. But in remaining 2 matters, the LCRs are yet to be received.
Your lordship, in item number 45, service is completed, LCR is awaited. In 46, we will appear on behalf of SGHC, respondent number 2, and we will file Wakalatnama. And in 47, same. And in 48, SGFC, we R1 and R2 appeared and LCR is awaited.
Okay, one by one then. Item number 45, Learned Counsel, Miss
Disha Goswami.
D.
On behalf of R. Goswami.
Miss D. Goswami is present on behalf of Learned Counsel, Mr.
R. Goswami.
R. Goswami, comma, representing the appellant. Full stop. Learned Counsel,
Boro.
Miss
A
A.
Boro.
Boro is present for
For the
the
caveat.
caveator.
I am for respondent number 2, lordship.
And Learned Counsel, Mr. SP Sharma is present for the respondent number 2. Caveator is respondent number 1.
Yes, lordship.
How many respondents we have in item number 45?
45 respondents. 2 items. There are 2.
Only 2, no?
respondents, your lordship.
Okay. Do we have the LCR of the?
No, my lord, LCR is awaited.
Trial 45. Wow. Okay. Trial court records have been received. $45 or very what? Nine. 593 case number किमान होएगा?
108/2026.
No, 40 same case হ'ব নেকি? 242 of 2019? নাই, এইটো বেলেগ case হয়, single case হয়। এইটো পালো নেকি? এইটো record নাই পোৱা ন? LCR is submitted. Is not received. The trial court records are not received. And is thus awaited. List this matter on date of delivery, no?
Lordship, can it be on 29th of May?
29th of May can be. Can be on 29th of May? Yes.
Lordship, one more prayer. There's one more connected matter, that is Meg Appeal 112 of 2026. Let this matter be taken in along with the other matters.
Along with Likidia, along with
The other matters.
Mac Appeal number
Meg Appeal 112 of 2026.
of 2026. Okay. Into IA 46 to the item number 47. Yes, item number 46, Learned Counsel, Miss
A Boro.
A Boro, no.
Disha Goswami.
D Goswami is present on behalf of
R.
Learned
Goswami.
Counsel, Mr.
R. Goswami.
R. Goswami. But your name is not in the cause list in item number 46.
No, my name is not there.
Even R. Goswami's name is also not in the cause list.
No, we will appear on behalf of respondent number 2, SGFC.
Okay.
We will file Wakalatnama.
Is present on behalf of and has submitted that they will file Wakalatnama on behalf of respondent number 2 in this matter. Ta agot likhi dia Learned Counsel, Miss A Boro.
Yes, Lordship.
A Boro is agot likhi diba ha. A Boro is present for the appellant. Learned counsel, Mr. S.P. Sharma is present for respondent number 1. Two respondents here in this case also?
Yes, Lord.
Yes, Lordship. LCR ahile niki? Shall I call for the LCR? Not required.
It's required.
593 ahise. Itu order.
Yeah, this is 592, 46 words.
46 or not. Trial court record as call for is received. No, no. 243 hai. 593 no. Huh?
Item 46.
Oh,
592.
243 hai niki? My case
243.
number. LCR. আগৰ কেছটো 243 হয় নেকি চেক কৰিছ হল 45 243 নেকি জাজমেন্টটো নহয় 242
Yes.
Trial court record is received. List this matter on
29th of May.
Actually, in item 46, so we are yet to obtain a copy of memo.
242, 243, ekata judgment hai niki? Common judgment niki?
Common.
Oh, hoy.
Analogous cases.
এতিয়া TCR not received to apply দিব।
এই আগৰ TCR not received to apply দিবা। নহয়। বেলেগ judgment 108 no?
108.
Common judgment নহয়। একেটাই ঘটনা হ'ব পাৰে কিন্তু জাজমেন্টটো কমন নহয় 242 নাই আৰু নাই ভাৰ্সাস আছে ন আৰু ভাৰ্সাস নাই জাজমেন্টে আৰম্ভ হ'ল ডেটটো লৈছে
TCR received as
46, let's say we have not received a copy of memo.
Okay. Extra copies to be to be served on the respondent to the respondent number 1 by the appellant. Then 47. Learned counsel Miss A. Boro is present for the appellant, and 46 also you have not appeared. 47 also you have not appeared.
We will file wakalatnama.
And learned counsel Ms. D. Goswami on behalf of learned counsel Mr. R. Goswami has submitted that they will file one wakalatnama to appear on behalf of respondent number
2
2.
SGFC.
Full stop. Learned counsel Mr. S.P. Sharma is present for respondent number 1. Full stop. Trial court records
received.
Trial court records as called for is received. List this matter on
Case when case number 251 of 19.
একে কেস ইয়াত গম পাই যাম জাজমেন্টৰ কপি দিব ন নাই এটাই কেছ Trial court record is received. Trial court record as called for is received. List this matter on 29.
Hello.
Item number 48, learned counsel Miss D. Goswami is present on behalf of learned counsel Mr. R. Goswami for the applicant. Full stop. Learned counsel Miss A. Boro is present for the caveator. And learned counsel Mr. S.P. Sharma
Respondent number 2, Lordship.
is present for the respondent number 2. Trial court record, no. Trial court
LCR
record
is
is not
awaited.
received. Await for trial court record. List this matter on 29. TSL 29 ki? 29 May. Full stop. Caveat ata ase nahi? Caveat to discharge kori diba. Caveator is present. It has been discharged, no, earlier? Caveat?
It was discharged earlier.
Earlier discharge kori thisi. Nai, caveat to diya nai to. Okay. Caveat likhi diba. Parties are, caveator is present. Miss Abel is present for the caveator. Caveat thus stands discharged.
Obliged.
এটাকে দিয়ে তারপর হয়ে গেছে এটাকে দিয়ে আছে না
It's up to 6626. Let me see. Oh. 4459825.
Hello. Where was that? I তিনজনের সাথে হইলে আমার কাছে বলে পুরো তিন নম্বর পুরো করা এর মবি বলা কারণ হইয়া তো কই সব কোন বলে আমার ফোন নাই এসে নাম্বার দিয়ে দিই Pero ya no me cae en para ir para la ciudad. Vamos a ver.
अभी नफे भी है আপনার কোড আছে তেইশ আর দুই তেইশ আর দুই বাকি কিছু মিলাতে বলবি নাকি করে মমিক নিয়ে আছে তাই
Online.